Right now, the Senzo Meyiwa trial has been postponed to the 2nd of May next year. This after accused number 1 and 2 received new legal counsel. To discuss this further, we are joined by Elton Hart, University of Johannesburg Law Clinic. Mr. Hart, thank you very much for joining us here on eNCA. I'm just wondering what you thought. Obviously, the first question, Advocate, would be about, the wheels of justice turning so slowly in this particular case. Of course, the accused do have the right to change legal counsel, but the meaning of this to the Meyiwa family.
Now, obviously, changing your legal representative in the middle of a trial that's ongoing, that will definitely have a bearing on how long it will take for the trial to conclude. And this for the Meyiwa family is another delay. And as the saying goes, justice delayed is justice denied. I don't totally think that this case won't come to an end, but it means that the agony of the Meyiwa family is just dragged on for a minute longer. And also the reasons advanced by the new legal representative for accused 1 and 2, it's a little bit flimsy because he had instructions already on Thursday. He could have alerted the court by Thursday already, or earliest Friday morning, to say before I go to Randburg court, I can pass by court to actually just notify them. And this for me, it's now like it's putting a damp on it, and it's making things just go at a snail's pace, and which is not right, and it's not fair because it's taxpayer. It's a waste of resources because the witnesses were subpoenaed, everybody was there ready to go, and then they dropped this bombshell this morning to court.
Of course, there were questions about TT Tobani, who used to represent accused number 1 and 2, and his decorum in court after there was that exchange with the judge last week. And I wonder if you think this is an indictment on him as an attorney, that accused 1 and 2 have now essentially fired him.
I won't necessarily think it's an indictment because what happened last week, the interchange that was between Judge Maumela and TT Tobani, I think there was wrongs from both sides. The judge did not conduct himself properly when he was confronted by how TT Tobani approached him. He also raised his voice, and you could also see that there was also a condescending tone coming from the judge as well as from TT Tobani. So both of these two legal practitioners, because both of them are legal practitioners, was not in line with the decorum of court. So I don't think necessarily that the accused person should have done that, but I can see here it was an instruction that was given by one of the accused parents. So I don't know even if it was the accused themselves who terminated the mandate more than the parents, because sometimes the parents might feel like Tobani is not doing what they're asking him to do, and the judge is getting hot under the collar for him. And the perception is also out there that the judge doesn't like Tobani at this point in time, and hence maybe they felt like, hey, maybe if we change the legal representative, maybe the judge's approach to accused 1 and 2 will also be different, because he's actually the extension of accused 1 and 2. So I think it might be along those lines, and not necessarily the accused persons felt that Tobani was incompetent in actually handling their case. But I mean, this is now purely speculation, but that's the lines I'm thinking around.
And of course, if the accused number 1 and 2 believe that perception that Judge Maumela doesn't like TT Tobani, I can imagine how accused number 2 feels, Mangani Ntanzi, because he was pointed out by the last witness to take the stand as one of the people who were definitely physically at the house. Although we have been told by legal counsel here and experts that that identity or identification of Ntanzi wouldn't really stand. But tell me, in terms of what you think, I guess they didn't have a choice but to accept this, because it's unlike a civil matter where a client has to give their legal representative a certain amount of time to let them know that they're changing so that they can serve notice, sort of. In this case, because it's a criminal matter, you can just wake up the next morning and decide, I don't want this lawyer, I'd rather have another one.
Indeed so, but it's also the same in civil procedure. You can, civil or criminal procedure, doesn't matter. If I wake up tomorrow and I say, I don't like a lawyer, I'm not happy with the service they render, I can terminate the mandate. The only thing that I need to do as a client, I need to pay that lawyer for the services that he has rendered from me giving him instruction to represent me up until that time. If I pay it, then I can terminate the mandate. So for me, you can terminate the mandate of a lawyer at any given stage, and when that termination notice comes to the lawyer, he needs to then have sort of a consultation with the client to just explain where's the process, what needs to happen, and then give the clients all the necessary documents that he or she has in his possession so that the client can approach another legal representative. But another legal representative, and the problem that I have here in this case is that they only found out at court that this new legal representative comes on board for 1 and 2. He did not even have time to actually liaise with his colleague, because that's also part of our code of conduct, that I would speak to my colleague and say, listen, yeah, this client has approached me to represent him further. I know you currently the attorney of record. Was your mandate terminated or not? And discuss it with your colleague so that you don't have that burnt bridges amongst colleagues. We need to be collegial to each other. And I think that is most probably what went wrong in this case, because Titi Tobani was also surprised and he wasn't given a proper instruction. So I think that was also maybe the displeasure that the court might have had with the new legal representative coming on record today to come and inform the court of this.
Especially, today we were expecting to move forward because the state did have its third witness ready to take the stand. But in terms of the fact that Bongani Ntanzi, accused number 2, has made an application for bail, we are still waiting for the outcome of that. He was represented by TT Tobani. And I know that the judgment in this matter might not necessarily be affected, but I want to know from you if it will be affected if maybe the judgment doesn't go according to the way he would like it, and he would need to take more legal action after that. If he decides that he's keeping this new lawyer, does it affect proceedings in terms of his bail application if judgment doesn't go his way?
No, indeed. The thing works like this. When it's a bail application, and if you bring a bail application and your bail application is denied, because it's an application, they can deny it or grant it. Now, if it's denied, the only other alternative available to him is that if he brings a second bail application, then he needs to bring new facts to the table to say that the court, here's some additional evidence that was not taken into consideration in granting or denying me bail. And I want you to consider this new evidence. But to just come and say, listen, yeah, I want to go on the old evidence, it doesn't work that way. Bail is a little bit some sort of a sui generis process. So he has to bring new evidence. And obviously, if he wants to, he can appeal the decision to say that the court did not apply themselves properly to the facts before court currently. So one has to wait and see. But if he wants to bring a second bail application, that will be new facts. But if he wants to appeal the outcome of the current one, then obviously he has to first wait to see if bail is denied, and then he can take that decision on appeal. He's allowed to do so, to take that decision, because it's an order of court. So he can take it on appeal. But if he brings further bail applications, then he needs to also produce new facts that says it will be in the interest of justice, and also there's exceptional circumstances why he should be granted bail under the circumstances.